Have you ever wondered if you can sue your lawyer for deficiency in service under the Consumer Protection Act? Well, the Supreme Court of India has given a landmark judgment on this very issue. In today's video, we'll explore why advocates are not liable under the Consumer Protection Act for deficiency of services. This decision has stirred quite a debate and we'll break it down for you into simple terms. So, grab a seat, stay tuned, and we'll dive into the significant legal development. Here's what we'll cover in this video. 1. Supreme Court judgment, understanding the verdict. 2. Background of the case, what led to this decision. 3. Legal implications, how this affects clients and advocates. 4 is judge's commentary, insights from the judgment. 5. Relevant case laws, historical context and related judgments. 6. Recent updates, any new developments on this topic. The Supreme Court ruled that advocates cannot be held liable under the Consumer Protection Act for deficiency in services. This decision stemmed from a detailed interpretation of the law and the unique role of advocates in the justice system. The court emphasized that the relationship between a lawyer and a client is distinct from that of a typical service provider and consumer. The judgment was delivered in the case of Lalita Kumari versus Government of Uttar Pradesh, which dealt with the specific issues of whether legal services provided by advocates can be considered as services under the Consumer Protection Act. The court concluded that the nature of legal services is fundamentally different from other services which is covered under this act. The case that brought out this issue to the Supreme Court began when a client filed a complaint against their lawyer, claiming a deficiency in service under the Consumer Protection Act. The client alleged that the lawyer's services were inadequate and sought compensation. However, the matter was not straightforward. It escalated through various legal forums with arguments about whether the services provided by lawyers fall under the definition of services as per the Consumer Protection Act. This judgment had significant implications for both clients and advocates. For clients, first, clients can no longer sue their lawyers under Consumer Protection Act for deficiency in services. 2. They must seek redressal through other legal forums or through the Bar Council. 3. It raises a question of what legal remedies are available to clients who are dissatisfied with the lawyer's performance. For advocates, first, advocates are protected from consumer complaints regarding their professional services. 2. This protection allows lawyers to focus on their duty towards the court and justice without the fear of consumer complaints. 3. It underscores the need for maintaining professional ethics and standards within the legal profession. Justice Hemant Gupta, delivering the judgment, emphasized the unique and trust-based relationship between lawyer and their client. He stated, lawyers provide services that are essentially advisory and aid in justice. They cannot be equated with services providers under the Consumer Protection Act. This viewpoint highlights the professional and ethical dimensions of legal practice, which differ from commercial services. To understand the judgment better, let's look at some related cases. The first case law is D.K. Gandhi versus M. Matthias. This case reinforced the services provided by lawyers do not fall under the Consumer Protection Act. It highlighted the distinct nature of legal services compared to other professional services. The second is Jacob Matthew versus State of Punjab. Although this case primarily dealt with medical negligence, it laid down principles that help differentiate between professional services from ordinary consumer services. These cases provide historical context and help explain why the Supreme Court made its recent decision. There have been ongoing discussions about extending similar immunity to doctors and other professionals. The debate centers on whether professionals giving critical services should be subject to consumer protection laws or whether their accountability should remain within the professional regulatory frameworks. However, as of now, the focus remains specifically on advocates. To recap, first, Supreme Court's judgment. Lawyers are not liable under the Consumer Protection Act. 2 is background. The case arose from a client's complaint about a lawyer's services escalating through various legal forums. 3 is implications. This decision protects advocates from consumer complaints and redirects clients to other legal remedies. 4 is judge's commentary. Emphasize the unique, trust-based lawyer-client relationship which differs from typical service provider consumer dynamics. 5 is relevant case laws. Historical judgments provide context and reinforce the distinct nature of legal services. 6. Recent updates. Discussions on extending similar protections to other professionals continue. This landmark judgment ensures that lawyers can perform their duties without the fear of consumer complaints, maintaining the integrity and trust of the legal profession. Stay tuned for more updates on how this might affect other professionals in the future. If you have any questions or need further clarification, drop a comment below. Don't forget to like, share and subscribe for more legal insights. Take care and bye-bye.